So good afternoon or good morning, good evening, wherever you are. Welcome all to this Refugee Law Initiative Conference panel session on injecting new life into international refugee law. I speak from experience when I tell you that aging gracefully may actually from time to time require injections of new life and fresh energy. And this panel is designed to introduce and discuss three complementary ways of re-energizing international law. International refugee law, obviously, considering along each development pathway the roles and responsibilities of UNHCR. We will hear about UNHCR's vision of soft law creation, monitoring and development. We will discuss the potential for hard law creations through optional protocols to the 1951 Convention as it turns 70. We will also be discussing ways to reconcile the UNHCR Handbook, a major source of guidance for many decades, with different dynamic understandings of some of its more controversial provisions. So I think we set for a very exciting discussion, and thank you for joining us. Before we start, let me remind you of some of the house rules. Our speakers will start by presenting their own perspectives, and it's after those papers are presented that we will open up for broader discussion. Each of the speakers will have between 10 and 15 minutes for their presentation, and I've been asked to enforce these time limits strictly. During the session, please pose your questions and comments to the speakers, not by speaking. Please keep your mics on mute, but by typing your questions into the chat box, which I hope you're all familiar with, the chat box on the screen. After we have finished our presentations, there will be time then to pick up some of these questions, all of them if possible, and to discuss and reflect on your comments. Again, please remember to keep your mics and on mute and your videos off, unless, of course, you are a presenter. The session is being recorded. It will be posted on the RLI website as a podcast. If you do not wish to appear in the podcast, then please leave the session now. If you wish to hide the live transcript at the bottom of your screen, please click the Hide Subtitles button. Those being the rules, it's now my pleasure to introduce our first speakers. Gillian Triggs, Assistant High Commissioner for Protection, and Madeline Garlick, Chief of Protection Policy and Legal Advice, also at UNHCR, will present a joint paper under the title Soft Law and Hard Questions. Again, do not forget to mute your mics and put your questions to our speakers on the chat. Gillian, Madeline, you now have the floor for 15 minutes between the two of you. Thank you in advance.
Well, thank you, Jean-François. Thank you to the Refugee Law Initiative, and especially thank you to the very significant number of people who are taking part in this conference. And I'm already seeing some messages in the chat box from people from all over the world. So it's enormously encouraging to us at the UN Refugee Agency to know that you're so keen to follow this discussion. And I look forward to the questions. Well, the question that's been posed for us today is whether the Refugee Convention at 70 is aging gracefully. Well, I do recognize, of course, that the convention is no longer in the first flush of youth, but I suggest that it's maturing to respond flexibly and with pragmatism to the almost unprecedented challenges of the 21st century. In 1951, the founding states were concerned to protect about 2 million displaced people who remained without security 6 years after the end of the Second World War. Today, the UN Refugee Agency has a mandate covering 82 million, approximately, refugees and people displaced in their own country, plus unknown millions of people who are stateless. Well, what are the challenges of the last few years? Well, an obvious one, of course, is the pandemic. It's seen many states derogating from key international human rights and refugee law principles, and in some cases, simply disregarding them while invoking public health as a justification for disproportionate laws. At the height of the pandemic, we saw 168 countries close their borders, and today we have 52 countries in which access to territory for the purposes of asylum is completely denied. We've also had striking instances of refoulement that are becoming commonplace, exceptionally in the past, yes, but today we have more and more states willing to refoul even explicitly. We've had the lowest level of resettlement for nearly 20 years, with fewer than 23,000 people resettled through the UN agency's submission process in 2020. We are, however, optimistic that numbers will rise over the coming months, with the United States in particular coming in with significantly increased numbers. But also voluntary repatriation has become extremely difficult with protracted conflicts. Afghanistan's in its 5th decade, Syria entering the 11th year, Myanmar, where Bangladesh has hosted Rohingya over decades, and most particularly in the last 4 years. Significant conflict in the Sahel and DRC, and new conflicts in Ethiopia and Tigray, and most recently, Mozambique, where I was on mission with my colleagues. We've also found, of course, the need in the context of few resettlement places and very difficult opportunities, or very few opportunities for voluntary repatriation, the need to talk about inclusion in economies much more forcefully than we have done as advocates in relation to health, access to work, education, social networks, and of course, vaccines. We've also seen some very problematic moves by some states to externalize their international protection obligations, worrying examples from Australia, from the United States, until we saw a change of administration, now proposed by Denmark, and other states exploring the idea, often under the guise of COVID or of development and investment in countries of origin and transit. We've seen express derogations from human rights obligations, and we've seen a consistent conflation of irregular migrants with those exercising their right to seek and enjoy asylum. These developments make clear the need to advocate more strongly to reinvigorate the key principles in international refugee and human rights laws to ensure that they continue to be respected, including during times when state resources and capacities are under strain. In time of crisis, we've consistently highlighted that protecting public health and respecting the rights of refugees are not binary questions. On the contrary, states can do both. And in many cases, of course, states have done so, particularly by resorting, as a silver lining from COVID, to greater technological and digital processes. Well, I'll speak to you today briefly on the role of soft law in the development of international refugee law, as illustrated in particular by the Global Compact on Refugees. And my colleague, Madeline, will subsequently speak about our guidance work, the Handbook on procedures and criteria for determining refugee status, and then the complementary guidelines. But to begin then with hard law, and you all, I know what this is. It's, of course, the UN Human Rights Conventions and Refugee Conventions itself that have been vital in providing the foundation for UNHCR's work over the last now 70 years. The 67 Protocol, of course, was a seismic shift away from the temporal, or for many contracting states, geographic limitations of the original convention that opened up the way for international protection for millions of refugees globally. And similarly, we had the 1969 Organization of African the Organization of American Unity Convention, which was a turning point for refugee protection in Africa. And at a regional level, the EU's common European asylum system was established with binding rules governing the treatment of refugees in Europe. And states continue to accede to the 51 Convention, most recently South Sudan in 2018, and critically to other human rights treaties that provide the content for many of the rights accorded to refugees under the Convention itself. I suggest that the continued adherence to these hard law agreements demonstrates their enduring relevance to states as they try to address the huge increases in displacement and protection needs in recent years. Some scholars make the case for drafting a new protocol to the Convention to advance the law itself and to respond to evolving needs, such as climate-driven displacement and gender-based violence, which has been a huge feature of the COVID pandemic. At UNHCR, we recognise the potential for further binding instruments could well be pursued wherever there are realistic opportunities, but it needs to be understood, and we know this well from our practice, that the appetite among governments is limited for negotiations on new legally binding obligations. The practical challenge, I suggest, in the current political environment is to reinvigorate the commitments by governments to the existing law. For many states are using COVID, economic challenges, and the irregular arrival of migrants as cover for disproportionate measures which restrict access to asylum and to the rights protected by the Convention, particularly the right to livelihood and to freedom of movement. Well, with an eye to pragmatism and our goal of ensuring protection for refugees and those forcibly displaced, we need to use the tools of international law to shape existing norms, including a focus by UNHCR on non-binding guides, advocating for the implementation of multilateral declarations and resolutions. But this brings me to my particular topic, that UNHCR can also develop soft law which can contribute over time to the development of legal norms. Hard law is, of course, conventions, covenants, and protocols, which are binding in the full sense of international law. But soft law includes declarations, resolutions, plans of actions, and guidelines. They're not typically binding, but they are nonetheless recognized as exerting some persuasive influence on state behavior in the international sphere. There are some various analytical and scholarly approaches to hard and soft law, but it is generally agreed that hard and soft laws interact with each other and can be complementary to develop international law progressively. There are lots of examples, and one that always comes to mind is the Universal Declaration of Human Rights, which, adopted as a non-binding declaration, some of its principles have now evolved into customary international law. And then there are many other examples. But the example I'd like to focus on in the time I have available is the Global Compact on Refugees, which I suggest is likely to play a very significant role as soft law. Agreed in 2018, affirmed by 181 states of the General Assembly, it has near universal endorsement. It's non-binding, but the high degree of attention devoted to it over the last 3 years is testimony to the influential role it's already having in shaping the conduct of refugee law in practice. It suggests that the Compact is a significant soft law breakthrough in adopting two core ideas. The first, while the Refugee Convention imposes obligations on states unilaterally in the traditional way of treaties, the Compact adopts the principle of equitable sharing of the burden and responsibility for refugees and those forcibly displaced. I don't like using the word burden. I try to avoid it and emphasize that we're talking about equitable sharing of the responsibility. But the second element is that the compass includes a much wider range of multilateral stakeholders: civil society, non-state scholars and experts, refugees themselves, provided substantial input before the states finally negotiated the text and voted to affirm it. Substantively, the compass sets out two goals. It recalls the fundamental principles of refugee law, repeating the cardinal principle of non-refoulement, international cooperation, and the key rights, freedom of movement, among others, in the Refugee Convention itself, along with the human rights principles that underpin all elements of international protection. In this way, as a non-binding soft law document, the compass reiterates and affirms the hard law obligations as a new expression of commitment by states. Compass, however, is also unusual in providing practical and concrete means to give effect to its principles. And these are very particular. One example are the support platforms, the MERP support platform on Central America and Mexico, the Nairobi process facilitated by IGAD in the Eastern Horn of Africa, and the SARS support platform for Afghan refugees, all of which were formally launched at the Global Refugee Forum in December 2019. These platforms have proved to be something of a success story over the last 3 years. They are variously developing according to their regional approaches, but they are a mechanism for bringing together regional support and political support in some of the most conflict and unstable parts of the world. It's now even proposed that a new support platform will be developed for the Central African Republic. Another mechanism for improving the way in which the compact can work in practice is the Asylum Capacity Support Group, which facilitates matching commitments by states to provide capacity development. The compact also focuses on ways to develop livelihood and self-reliance opportunities for refugees, which we know is absolutely critical for refugees' dignity and for their ability to survive in the environments in which they find themselves, in light of the point that I've made earlier that resettlement and voluntary repatriation is becoming increasingly difficult to achieve. In this way, the soft law text complements and builds on the hard law to enable refugees to enjoy their rights in practical terms. Another challenge for the compact was to ensure that it's not just another set of words on the page. A non-binding endorsement with lofty ideals, which of course the compact does include, we needed to be sure that the words would have practical and concrete implementation. And in December 2019, the Global Refugee Forum was a huge boost to our confidence in the compact here at UNHCR. That is, we had over 3,000 representatives come to the Palais in the days when we could meet together, with over 1,400 pledges made by civil society, by governments, NGOs, the private and corporate sector, faith-based groups, the academy, and by refugees themselves. While the forum was immensely encouraging, a few weeks later, the world was hit by the COVID pandemic. So the question today is whether the pledges will actually materialize. And over the last 18 months, UNHCR has been monitoring progress on implementation in practice, and in November, will provide hard data and evidence of impact in anticipation of the high-level officials meeting to be held in December. In other words, there is a continuing process by which the lofty ideals of the compact will be given practical effect and monitored so that we have clear evidence with 15 indicators of impact and implementation to produce for the high-level officials meeting. So I'd suggest that it's become clear over the last few months that despite its non-binding nature, the Global Compact on Refugees and its follow-up arrangements have stimulated progress towards realization of the rights of refugees in practice. And they've confirmed the commitment of the international community to core international refugee law. We hope that over time, the compact will lead to improved state practices, especially to equitable responsibility sharing globally, to admission to asylum processes, access to livelihood and other rights, and to improved opportunities for durable solutions. So in sum, soft law can give, I'd suggest, substantive content to and complement hard law rights enshrined in the 51 Refugee Convention itself, informing the interpretation, application, and progressive development of refugee law. So let us see if the evidence of the implementation of the compact for the high-level officials meeting proves me right. If so, I will be very confident in saying that soft law can be effective in achieving real protection outcomes. So I turn now to my colleague, Madeline Garlick, who will speak more specifically on the handbook and the ExCom conclusions. Thank you all very much.
Thank you very much, Gillian. And let me just in a couple of brief minutes speak about a couple of specific soft law instruments, UNHCR's Handbook, Guidelines on International Protection, and ExCom conclusions. aiming to highlight briefly the ways in which they can contribute and indeed have contributed to the development of international refugee law, as well as a few ways forward around their development and use. UNHCR's Handbook is, of course, a key source of soft law guidance, prepared in 1979 at the request of states in UNHCR's Executive Committee. The Handbook has been described by the Supreme Court of Canada, the UK House of Lords, the Supreme Court of the US, as a highly relevant authority, highly persuasive authority, and providing significant guidance, respectively. The UK Supreme Court has also stated that the UNHCR Handbook should be accorded considerable weight in light of states' obligations under Article 35 of the 1951 Convention to facilitate UNHCR's duty of supervising the application of the provisions of the Convention. Whilst evidently drafted at a particular historical moment in 1979, the Handbook has proven remarkably resilient and durable in its relevance and application, continuing to provide pertinent guidance to address many of today's international protection challenges. At the same time, it's clearly important to reflect and address changing patterns of practice and approaches to the interpretation and application of the law, which UNHCR has sought to do, amongst other ways, by issuing guidelines on international protection, which I'll refer to in a minute. But in addition, at this point in time, a reassessment and revision of the Handbook could well be warranted in coming years to enable it to incorporate reference to recent law and practice, both that supporting its guidance and other relevant standards, but also to address some practice and trends that have appeared to depart from the correct legal approach and interpretation of the Convention and other legal instruments. Such a revision process would need to do three things. Firstly, to involve wide consultation, bringing in not only developments in law, practice and jurisprudence, but also expert thinking, research and writing, drawing on expertise and insights from just tackling the button there.
Are you okay?
I think, Gillian, if you could unmute yourself, then that would help Madeline's audio.
Okay.
Do you hear me now?
Yes, but there is a strong echo.
Okay.
Let me just remind you that, unfortunately, you have only 2 minutes left.
I'll proceed. Thank you, Jean-François. I hope you hear me now.
Yes.
Turning briefly to the guidelines on international protection. Of course, since 2002, UNHCR has issued 13 guidelines on international protection, the most recent on Palestinians, and is now working on one in relation to Article 31 of the 1951 Convention on penalization. The process of producing the guidelines on international protection has been refined over the years and now generally includes production of an exhaustively researched background paper, an expert roundtable bringing together state and non-state experts, a public consultation stage during which the draft guidance is posted on UNHCR's website and comments invited from interested parties, and finally a rigorous internal clearance process by UNHCR's management. Some of the guidelines on international protection have been criticised over the years, including for purportedly extending beyond UNHCR's mandate or for failing to take account of some relevant scholarship, legal developments or jurisprudence. On the other hand, we've also had a number of courts who have talked about their importance as a source of guidance on the interpretation law, including under Article 31 of the Vienna Convention on the Law of Treaties, reflecting in the words of the Canadian Supreme Court, practice in the application of the treaty. Questions about the scope and applicability of the guidance have been well heard, and different steps in the consultative process, which has been opened significantly over recent years, aim to remedy some of these weaknesses. The challenge of producing continuously relevant guidance is not a small one, and so therefore we look to and welcome our partners' involvement in the consultative process to contribute analysis on developments and perspectives that should be taken into account in shaping this guidance. Finally, turning to ExCom conclusions, a different category of document produced by UNHCR's Executive Committee, now comprising 107 states. It's issued over 414 conclusions to date, the most recent from 2017 relating to machine-readable travel documents. And as we speak this week, a further conclusion is under the course of discussion relating to international protection and durable solutions in the context of a public health emergency. Clearly a highly relevant and timely topic. It's important to note in looking at the weight and the range of issues addressed in the Executive Committee conclusions to bear in mind that the committee is much larger and more diverse than at any time since its establishment. This means that discussions reflect very different perspectives, resulting in sometimes intense debate over the content of ExCom conclusions. We in UNHCR take heart from that. Member states are investing their attention and diplomatic energy on the ExCom conclusion process, we believe, because they feel that these matter, affirming the weight and influence of ExCom conclusions in states' eyes. To conclude, these three instruments all seek to address contemporary themes and challenges in operational as well as legal terms in relation to international protection of refugees and other persons of concern. They have been repeatedly described as being useful to courts, policymakers, academics, and others in decision-making, analysis, and formulation of policy and operational responses. In this sense, they can continue to contribute importantly to the effective application, as well as the ongoing development of hard refugee law. Thank you very much, and looking forward to the discussion.
Thank you very much, Gillian. Thank you, Madeline. It's now my turn, and I realize that I haven't really introduced myself when I started moderating this session. I am Jean-François Durieux, a former UNHCR staff member, now an independent analyst and senior research associate with the Refugee Law Initiative. And following on very much on some of the comments made by the Assistant High Commissioner for Protection, I shall address myself now in 10 minutes to the question of the desirability and feasibility of additional protocols to the 1951 Convention. I confess that I have a soft spot for hard law. When I write, as I did in the panel proposal, that international refugee law is a rather underdeveloped and static segment of public international law, I realize that I'm probably unfair to those in UNHCR and beyond who try to make the best of what the market seems to bear, which may be soft law. The question we must ask ourselves, nonetheless, is whether the accumulation of soft law instruments, justified at least in part by a desire to reaffirm and clarify existing treaty provisions, might actually over time undermine not only the authority of that body of law, of hard refugee law, but also, importantly, the authority of the international organization that is mandated to supervise hard refugee law and, importantly, to promote its development. Of course, it would be foolish of me to claim that for UNHCR to promote the adoption of more hard law on refugees will be an easy task or one that can be completed quickly. No, it's bound to be a slow and rocky ride. But to get it started would send a very strong signal that the international refugee regime needs binding commitments and that international refugee law is alive and kicking. What form should additional hard law on refugees take? To open the 1951 Convention, as we know, would inevitably lead to its unraveling, hence to a loss of the few but precious protection that it contains. The drafting of protocols would obviously avoid this risk, since protocols keep the mother instrument intact while filling its gaps. So let's talk about protocols, but at the same time, let's be attentive to some ideas that may even be more ambitious. For example, the idea of a framework convention on state responsibility for refugees, an idea that was launched in a very interesting article written in 2017 by Patrick Wall, who was and still is with UNHCR, an idea that was recently taken up by 3 Switzerland-based scholars on the Rethinking Refuge website. You may have seen this, trying to follow the example, mutatis mutandis, of what's happening in the climate change debate. And indeed, I believe that, ambitious as it may sound, a framework convention would be the ideal instrument to regulate responsibility sharing. In my full paper, which you will see, of course, upon request, no problem, with pleasure, I present the idea of a protocol on burden and responsibility sharing as both a very good idea and a rather bad candidate, after all, for a protocol. It's good because, as we know, this is where the rub is. Nothing can be more damaging to respect for the 51 Convention than the feeling of injustice that prevails among refugee receiving states when they realize that their legal duty not to return refugees is not matched by any firm obligation on more distant states to share the cost, much less to share the caseload. Even in well-resourced states such as the UK or Denmark, or Australia for that matter, politicians in government have threatened to burn the 1951 Convention at the stake for its failure to provide a measure of predictability in the distribution of asylum responsibilities. On the other hand, to deal with responsibility sharing through a protocol to the 51 Convention is, in my opinion, slightly far-fetched because the issue lacks a firm anchor in the Convention, aside from the preamble. And I've already seen a comment to that effect on the chat. The situation would be different if we had on the book a convention on territorial asylum, for example. Likewise, one could envisage, maybe one should envisage a protocol to the 1969 AU Convention on Refugees, because it has actually in the text a provision on responsibility sharing that definitely would deserve being clarified and strengthened. The 1951 Convention, for its part, is simply not about asylum as a shared responsibility, hence the difficulty of building a protocol upon it. Yet, as he was about to leave office, High Commissioner Antonio Guterres, now Secretary General of the UN, told this to his executive committee. If there is one protocol that is yet to be drafted to complement the 1951 Convention, it is one on international solidarity and burden sharing. Did he seriously mean a protocol? Was he committing his office to this objective? I'm not sure. Interestingly, that was not the only topic deemed to be ripe for a protocol by a High Commissioner for Refugees. Years before, upon closing the global consultation process, High Commissioner Lubbers mentioned the possibility of an optional protocol on supervising the implementation of the 1951 Convention. And surely such an undertaking would be consistent with developments in international as well as regional human rights law, where, as we know, treaty monitoring bodies have been instituted through protocols. States in the global north, in particular, cannot afford to be publicly seen as rejecting, in respect of the 1951 Convention, what they have accepted and what they practice in respect of the supervision and monitoring of other human rights treaties. Of course, an objection which was raised by Catherine Costello, who I hope is hearing us, is to say, but do we actually need a protocol on supervision? What stops UNHCR itself from being more systematic or perhaps even more aggressive on supervision? It's a good question, but perhaps the way to get there is for UNHCR to propose a system of peer review or an independent monitoring body. In other words, upping the ante quite a lot in order to reap perhaps a more modest result, such as UNHCR making its own protection reports public. That would still represent a major improvement over the status quo. I will briefly mention in the few minutes that are left three more areas, which in my paper I have tentatively identified for the adoption of protocols. One would be a protocol on refugee children. Perhaps not necessary in the sense that there's already a fair amount of hard law emanating from human rights law that protects refugee children. However, here we have a sort of low-hanging fruit. which is of tactical value. In my view, it's pretty safe to start an ambitious lawmaking project with a more consensual subject matter than, for example, supervision or burden sharing. So this is something to be considered. The next candidate in line, and maybe the first one that, certainly the first one that has sprung to my mind, is gender-based persecution. When it comes to grounds of prohibited discrimination, let's face it, the 1951 Convention shows its age. It lags far behind human rights law in its ignorance of inter alia gender as a ground for persecution. And we all know how creatively or less creatively case law has dealt with this issue, not least by using the membership in a particular social group ground. But to be frank, I fail to understand those advocates of women's rights and gender equality who insist that membership in a particular social group is the right vehicle for gender-based claims. I believe that creativity cannot be an end in itself, especially where the objective is to give the visibility it deserves to a widespread and vicious form of persecution. Visibility requires that gender, or at least sex, be openly acknowledged as a ground for persecution in the refugee definition. Now, is there a danger, as a matter of international law interpretation, that having a protocol adding gender to the list of persecution grounds would lead to an interpretation of the existing definition as not covering this? This is a good question, again posed by Catherine Costello in a previous conversation. I personally cannot think of many states that would actually argue this, but this may be certainly a point for discussion. And finally, I think through a protocol, one could come back to an idea which I've cherished and on which I've written for a long time, which is a derogation-like procedure in situations of mass influx. Some time ago, with Jane McAdam, we wrote, "The challenge in mass influxes lies in regulating the manner in which the passing of time affects the accrual of states' obligation under the convention." And in that article, we suggested that under-resourced states facing a refugee emergency should be allowed to derogate for some of their treaty obligations. The central point not being that they derogate, but that they do derogate in a manner which is strictly regulated and strictly supervised. In my view, if law cannot produce binding burden-sharing norms, then we must resort to law in order to give overburdened states a breathing space within strict limits, or we shall witness a further erosion of the convention. So these are my wild ideas about protocols, but I welcome, of course, the comments of everybody in the audience and also a further conversation on this. Thank you very much for your attention. And I will now, while monitoring the chat for your questions, please keep sending them. I'm now very happy to give the floor to our final speaker, Hugo Storey, who is a retired upper judge tribunal and until recently president of the European chapter of the International Association of Refugee and Migration Law Judges. And you will talk to us, Hugo, about the UNHCR handbook. Is it a white elephant or an eternal flame? Well, I really look forward to getting your views on that. You have the floor. Thank you very much.
Thank you, Jean-François, and it's a delight to be part of the panel. Time is short, so I'm going to zoom straight into what I think is Gillian and Madeline's third category of soft law, which is UNHCR's legal interpretive guidance. And you'll see from my abstract that I consider that the handbook has various shortcomings, and I regard it as increasingly incongruous that UNHCR should still, over 40 years on, identify it in unqualified terms as its primary authoritative interpretive source of guidance on the refugee definition. And I didn't mention in my abstract any specific criticism, so let me just mention a few now. First of all, just framing things as they stood in 1979. Even then, the handbook had some evident gaps. It didn't, for example, cover all key elements of the refugee definition, in particular nationality or statelessness. It didn't identify the Vienna Convention on the Law of Treaties rules of interpretation. It contains virtually no treatment of the issue of the causal nexus with the convention grounds or reasons, and it contains no mention of the doctrine of attribution. But in any event, 40 years on or so, we've got to look at the handbook from a present day perspective and in the light of the accumulated experience. And there are a number of shortcomings have been mooted in the literature, and I'll mention the main ones. Its statement that subjective fear is an essential element of the concept of well-founded fear. Its absence of any identification of gender-specific or child-specific or disability-specific forms of persecution, which Jean-François just touched on indirectly. Its cursory treatment of socioeconomic persecution. Its treatment of the scope as political opinion as limited to opinions held regarding the authorities or the government, without consideration of them being held by non-state actors. Its statement that the test for internal flight or internal protection is an historic one. Its apparent confinement of the issue of protection of a country to that of diplomatic protection in the context of a multiple nationality, its reliance on a test of effective nationality, its adoption of an abnormalcy requirement in order for persons fleeing armed conflict to qualify as refugees, and its reliance on, in relation to deserters and draft evaders, on a test of condemnation by the international community. And in addition, there are certain developments which would unequivocally merit coverage in any modern day equivalent of the handbook. There's a chapter 5 on special cases, and I'm sure it would be very different if written today. It would cover, for example, victims of trafficking, persons basing their claims on a flight from natural disasters or climate change events, persons affected adversely by pandemics. And further, as the guidelines that Madeline referred to have come to highlight, there are numerous paragraphs that would now be written quite differently, and that's plain from the publication of the guidelines, for example, on gender-related persecution, among others, just to highlight what Jean-François was focusing on. So hang on, some of you may say whether, well, such criticisms, are they accurate? It's open to argument. Of course, it's open to argument. But my point here is that there is clearly no longer any consensus that the handbook has got everything right. Its authority is sometimes equivocal, to use the term that's come up in the literature. And secondly, I think it really is quite fanciful to expect a 1979 document to still be right in every respect, given that the Refugee Convention, which the handbook sought to interpret, is a living instrument. Indeed, if any of the drafters of the 1979 handbook were on this discussion today, I'm sure they would be quick to point out that it was never their intention to provide guidance of continuing validity for a further 40 years. And indeed, if you look at paragraph 221 of the handbook, that's pretty much what they're saying. It says the UNHCR is fully aware of the shortcomings inherent in a handbook of this nature, bearing in mind that it is not possible to encompass every situation in which a person may apply for refugee status. Okay, well, can we, as it were, rescue the handbook by treating it as part of a box set of UNHCR materials giving guidance? and including the EXCOM conclusions and the guidelines on international protection that Gillian and Madeline referred to. And I think there are two main points here. One is that nowhere in the guidelines or any other UNHCR guidance materials is there any admission that the handbook is not fully accurate about everything. UNHCR continues to portray the handbook as the first and most comprehensive interpretive instrument of the UNHCR, and all the guidelines describe themselves as complementary or supplementary. In my abstract, you'll see I call this the never disowning approach. And to me, it's an unhappy state of affairs because the world looks to UNHCR surely for authoritative guidance. And surely that should mean that if UNHCR knows that some aspects of the handbook are at least problematic, then it should say so. And I entirely agree that much of the handbook holds up, and that's a testament to the fact that it was based on 25 years of accumulated experience, and it's played a hugely progressive role. But as I said in my abstract, treaties get to age gracefully by virtue of there being living instruments applying Vienna Convention on Law of Treaties rules. But that's not true of guidance. There's no similar dispensation. And the second main point is this, that if you take the UNHCR guidance as a box set, even the guidelines on international protection, which is the main vehicle that UNHCR has chosen to produce updated and complementary materials, up to the present, it doesn't really cover that much ground compared with what the handbook was seeking to cover. And that's obviously intentional with some of the guidelines, which are meant to be on specific issues, horizontal gender-related persecution, child refugee claims, trafficking, and so on. But if you focus on, certainly on the inclusion clauses, what have we got? Particular social group, internal flight or internal protection, not much else. So looking at the trajectory of the guidelines since 2002, on present trends is going to take until the end of this century for UNHCR to complete a full coverage of every aspect of the inclusion clauses. So what can we do about this? There are, of course, ongoing efforts by judges and academics to provide clearer and fuller interpretive guidance. Think, for example, of the Michigan guidelines. And IRMJ is now involved, certainly within the EU, in producing judicial analyses. But in my view, the ball is very much in UNHCR's court. It is only UNHCR that has any international authority to produce guidelines pursuant to its Article 37 responsibilities, 35 responsibilities. It would be folly, I think, for any other actors to think that in the absence of there being any treaty monitoring body through a protocol or any other process to issue authoritative guidelines. They have to emanate, it seems to me, from UNHCR. So going forward, how might that be done? I think there are three main alternatives. One is the status quo, which I hope to have persuaded people is indefensible. And the second, which I call in my abstract, a kind of incrementalist approach, is to continue with the development of further guidelines and so on, but to start identifying where the handbook provisions are problematic, so that it's clear to the users what is considered to be still thought valid and what is not, and if so, why not. That seems to me would not mean retiring the handbook, but rather continuing to respect its foundational importance, but in a way that qualifies it where appropriate. And the other main alternative is what I call the substitutionist alternative, is a wholesale revision. And Madeline did mentioned that briefly. And I do think with the right methodology that sought engagement with a very wide range of stakeholders, including refugees, it could achieve a document that could accurately be said to represent state practice, which is no longer possible to say about the 1979 handbook. And finally, just to say, can I underline, I don't intend by what I've said to be Luddite. Until something else takes its place, the handbook and at least the wider body of UNHCR guidance must be treated as a starting point, certainly outside the EU, because for many decision makers in the world, they will otherwise try and substitute their own ideas and their national law approaches. Thank you very much.
Thank you very much, Hugo. Thank you to all the participants who have started posting comments and questions. As you continue, especially to address questions to Hugo's presentation, I'm now going to give the floor back to you, Gillian and Madeline. If you wish to pick one of the many questions that was put or react to one of the comments that was made on your presentation, please feel free to do so. I shall do the same, and then Hugo also will have an opportunity to react to some of the comments. Gillian?
Well, thank you very much, and thank you for the comments that have been made by my fellow panelists, but also from the chat box, which I've been trying to pick up. But I think given that it's fresh in everybody's mind, I should respond to the comments made about the handbook, and I think Madeline will respond as well. But what I can say is that we take your point. It is a very long time since there's been a comprehensive review and upgrade. I think I quite like the idea, excuse me, of identifying where the handbook is problematic and then starting a process. But we will certainly want to do that. And I think while I'm coughing, I'll pass to Madeline.
Thank you very much. And let me really thank the many participants who put forward really interesting and thought-provoking questions that certainly help UNHCR also in thinking about how to address some of our challenges. Perhaps I could speak first of all to the handbook point, as Gillian has touched upon. Indeed, Hugo, it's very good to hear that you see significant scope for us to build on the foundation that the handbook currently provides, and using UNHCR's supervisory responsibility to work towards a process whereby genuine consultation could be undertaken in order to get perspectives from the experts who are observing state practice worldwide, jurisprudence, developments and thinking that could help make it into a stronger document addressing current challenges. And I think this is indeed something that UNHCR needs to look towards. It's an ambitious undertaking, however, because I think we all recognize that this needs to be something that can really ensure real global relevance and speak to the challenges faced by countries that have national asylum systems and well-resourced institutions in order to manage refugee protection, but also many others that are in other situations and may have very different legal systems that will also need to be addressed. So indeed, if we were to look to a process of seeking expert perspectives in something akin to what the global consultations process did in the early 2000s, then this would be a process where we would look to our partners in academia as well as policymakers and judges and others in order to really ensure this would be the most relevant and authoritative form of guidance that could be provided to take the place of the handbook as it stands. I'd like to perhaps touch upon one of the questions that has arisen in relation to ratification. And there it's been suggested that a focus could be placed on seeking to garner more support for ratification of the 1951 Convention. Of course, what we've seen in the last few years is that considerable efforts being invested in seeking to try and build up scope for support for the more effective implementation of our existing provisions. And this, of course, is very much the raison d'etre of the Global Compact on Refugees, which seeks to complement binding legal provisions by providing practical means by which this can be done. This being said, wider ratification remains an important goal for UNHCR, and we're engaged in discussions with a number of states as we speak on possible ratification in the future. But I think the suggestion that's been made in the chat that we would need government support to really ensure that we could reach out to a number of states that are hosting large numbers of refugees and are not at present willing to do so would be an important part of that. And I think what we would need to see is very firm commitments to more responsibility sharing than we have now, in order to encourage those states that they should exceed in ways that are going to enable them to fulfill their obligations under the convention with appropriate international support. Perhaps just a final point on a question that's been raised in relation to a recent important court decision, which is linked to this, because what we know is that ratification alone is not going to be the answer to ensuring respect for refugees' rights in all circumstances. The question in the chat refers to a decision of the Supreme Court of India recently to refrain from gaining interim relief to a group of Rohingya refugees threatened with refoulement from India, which of course is not a contracting party. That decision was made, however, despite binding obligations under international human rights law around refoulement, as well as customary international law. So this clearly highlights that there remains an ongoing need to invest significantly in work around providing input and guidance to states, including through soft law instruments, through court interventions, advocacy, which we undertake with many of our partners to ensure greater respect for provisions that we have, which bind states, including from refugee law, but also human rights and other relevant bodies of law more broadly that are there and which can contribute to ensuring greater respect for the rights of persons of concern. Thank you.
If there's time, Jean,
go ahead.
Jean-François, can I answer one other question?
Yes, please go ahead.
Thank you for the question on examples of the pledges, because I really think this is pretty exciting, and it's the question in relation to India, the question in relation to Denmark sending Syrians back to Damascus do raise the issue of remedies, of enforcement, and of course they don't exist. But what is interesting about the pledging is that countries are actually living up to their pledges. And 15% of the pledges made, and that, remember that they were 1,400 of them, and more coming in after that time. So it's been a highly organic or a developing process. But 15% of these pledges are fully completed, and 70% are in process. Examples might include Côte d'Ivoire on legislation to prevent statelessness and ensuring birth registration. Another is Colombia's pledges in relation to inclusion. And they, as you may know, they've just passed some laws which allow a 10-year temporary protection status for what will potentially be about 2 million people from the Venezuela, or from Venezuela and the socio-economic and criminal action that has led to the movement of so many millions from Venezuela. But another and very particular one is France pledging through a matching process with Rwanda and Niger on strengthening the asylum processing system so that there can be a fair and fast system within Africa to possibly stabilize populations so that they will not be moving up through dangerous routes on the west of Africa or across to North Africa and the Mediterranean. So I think we can see some positive outcomes, and we will be reporting with evidence and data in November. Thank you very much. Back to you, Jean-François.
Thank you very much. Thank you very much. I will just very briefly follow up on this question regarding accession and the particular case of India that has been raised and already addressed partly by Madeline, because there is indeed an interesting question behind this whole question of the state of development of international refugee law. And that is what would be attractive to states that are currently not parties to the treaty. What would make it appealing to a state like India, though I guess that's one of the toughest candidates, but to want to be part of the club on a convention which, let's face it, has a language which is outdated and which can hardly be read without a reference to a much broader framework that gives it light, including the huge body of domestic jurisprudence that has evolved around it, and also developments in human rights laws. So it's complicated, but I think, to me, it's certain that if there was, as part of the legal package that come with the 1951 convention, firmer commitments on responsibility sharing, and perhaps linked, as I said, with some trepidation, linked to a supervised system of derogation in emergencies, that, to me, it seems would make the whole system more appealing. Again, when it comes to making the responsibility sharing more predictable or firmer, I think the Framework Convention is a great idea. I think it will be very difficult, obviously, to engineer such a new process now, especially when we're still fighting hard to get some concrete results out of the pledges under the Global Compact. A protocol is difficult too for the reasons I indicated, but let's face it, on the basis of the existing pledges and the lofty but important principles contained in the New York Declaration and in the Global Compact, if we manage to put in place a very strict system of compliance monitoring, if there are enough teeth in this, I believe, and I guess that is one of the gambles and the bets of the Global Compact as a soft law instrument, give it some teeth, harden it over time, don't drop it, for God's sake, because so many resources have been invested in it, as Brian very rightly put in his comment. So let's be very strict about it. And that may, in my view, create an incentive for states to join that so far say, why should I be bothered? I think that's an important point and certainly one worthy of reflection. I'll give you the floor, Hugo, if you want to pick on one or more other questions, including, of course, the comments that have been made by the other presenters.
Thank you, Jean-François. Unfortunately, I'm not able to see the chat questions, so I'll just confine myself, if I may, to follow up on the panelists' discussion. And there are really just two points I'd just like to emphasize. And one is that Madeline is quite right to emphasize that the handbook continues to be seen as authoritative by a number of very important bodies. Indeed, the Strasbourg Court, European Court of Human Rights, continues to defer to it. And the International Law Commission, in a 2018 report on the Vienna Convention on Law of Treaties and Subsequent Practice, referred to the handbook as state practice. But I think we've got to be realistic here, that these bodies clearly are not intending to endorse every single passage of the handbook. For example, to talk about the Strasbourg Court, I'm sure it would be a shock to the Strasbourg judges if they were seen to be endorsing a view that victims of harm or ill treatment have to show a subjective intention. And so I think if we don't, and I'm pleased to hear from both Gillian and Madeline that they do think that it's perhaps time to start identifying problem areas, then that will probably overcome my worry that otherwise these contradictions will just build up and it will begin to erode the general authoritative status of UNHCR materials. And the other point is really just about judicial guidance. And I thought it was quite apposite that the Indian Supreme Court decision was mentioned, because perhaps it is a good reminder of how imperfect a mechanism judicial guidance can be. And of course, judges talk a lot about horizontal judicial horizontal judicial dialogue, and of course that as well is a very imperfect tool. But nevertheless, and I think in terms of any future mechanism to try and revise the handbook, I think UNHCR does need to bear in mind that the case law that is built up, it wasn't foreseen at all by the handbook or indeed the drafters of the Refugee Convention, that there would be such a huge body of jurisprudence. And I think it's going to be important in any consultation process to reflect that in the way that value and weight is given to taking into account the range of opinions. Thank you.
I activate. Thank you all. We have some time for a quick second round. Madeline, Gillian, if you wish to follow up on this discussion or address one of the many other issues that have been that are popping up as we speak.
If there's a second, just until the next question, I think one of the suggestions that we might look at the possible protocol with regard to refugee children is something that I think, as I think you've said, that Jean-François, that there might be some tactical value in this, quite apart from the ethical and legal, and that is that more than 50% of the refugees and displaced people that we serve are children. And I think although I haven't been with the UN system for very long, I'm already starting to use UN language, and this terrible phrase, persons of concern, and other phrases, numbers, completely camouflage the reality that we're dealing with children to a very high degree. And having just come back from Bangladesh, that is, I think children are much higher than 51% there in the Rohingya children in Cox's Bazar. So I think something along those lines might be a possibility to give a greater focus on children, even though, of course, the Convention on the Rights of the Child is so powerful and so well recognized. Thank you.
Thank you. Madeline?
Yes, thank you, Jean-François. Yes, perhaps two quick points, again, picking up on the discussion, but also some of the questions. The idea of a formal derogation mechanism from the 1951 Convention, I think is a very interesting one that could warrant further examination. It has, I think, as you and Jane McAdam also, of course, have mentioned, significant potential, but also perhaps significant risks. And it would be important perhaps to look at what we have learned from experience with derogations made from human rights instruments over the year. And we've seen some of this in particular over the past 12 months, where a number of states in the course of the pandemic have formally made derogations from their human rights obligations under a number of treaties. UNHCR had observed some 31 at one point during 2020. Positively, we've subsequently seen a number of states that have then lifted those derogations as the situation has stabilized and as they have found ways to address public health concerns without limiting human rights. But nonetheless, we do see some other states that are persisting in their use of those derogations in ways that seem to suggest that perhaps there are other purposes behind it. So I think indeed this would be something that perhaps is worthy of further academic study and analysis to consider what its potential might be, and to look at what particularly it might provide by way of opportunities, but also some risks around the refugee context in particular. And I'm mindful too, where you've mentioned it as something particularly for situations of mass influx. That's a context which, of course, again, was specifically addressed by the New York Declaration and the Global Compact on Refugees. So I think we'd perhaps like to see if we can really give those arrangements and proposals a practical opportunity to work in order to assess whether these might of themselves relieve some of the pressure on states that are receiving large numbers of arrivals of people at one time. Perhaps I could then also specifically go back to a question from the chat that was posted early on about which of the international legal principles around responsibility sharing is specifically invoked and supported by the GCR. And there, I think we can particularly point, of course, to the paragraph 4 in the preamble to the 1951 Convention, which underlines that international cooperation is essential in order to address challenges around refugees, which are international in their scope and nature. And what we, of course, have in the Global Compact is a number of concrete mechanisms, practical mechanisms that seek to put in place structures and means by which states can provide each other some concrete support. And one of the things that's very interesting in that regard is the Asylum Capacity Support Group, which has been set up recently and where we're seeking to match states that are offering support and expertise with those that have expressed the need, but also support platforms that Gillian mentioned, where specific geographical and situational help is being provided. But also, I think interestingly and importantly, the pledges made by some of the non-governmental actors, and particularly those who have offered significant amounts of pro bono legal assistance, are potentially going to be really important ways by which we may see new forms of practice that do give us clear indications of what responsibility sharing and international cooperation can and needs to look like in order to ensure greater respect for refugee protection norms. Thank you.
Thank you. Thank you much. Hugo, I wonder whether you would be willing to react to they're coming in an avalanche, but anyway, one of the most recent submissions that talks about, that ask whether perspectives of the global south are or have been adequately represented in the interpretation of the convention through handbook or guidelines. Could you maybe speak to this also from your experience with the International Association?
Well, I think Jean-François, clearly, if you look at the published case law, there is an imbalance in that the jurisprudence of the global north has dominated. But I think there are lots of problems with that which aren't necessarily easy to solve. For example, in some of the African countries, there's not even publication of the judicial decisions and matters of that kind. And within the R&J context, I think that there is a feeling that more needs to be done to have the judicial voice of the global south injected into the broader perspective. But in terms of the interpretation of the refugee definition, I think what is interesting is that, for example, if you think of the human rights approach to interpreting key terms of the refugee definition, it's certainly not something picked up in the R&J context that there's any objection or dissent from that. And so at the moment, I think on many issues, there isn't a reason to think that there would be a contrary view. Thank you.
Thank you.
Jean-François, can I just add briefly to that?
Sure, go ahead. Yeah,
just to say that, again, to go back to the compact specifically set up and created the GAIN, which is a group of scholars globally. And one of the objectives of GAIN is to ensure we get the voice of scholars in the global south. Now, we have a long way to go, but I think it's an important initiative so that we start, again, pairing up scholars from the north with scholars in southern universities and scholarly institutes and so on, who can start writing articles together, start comparing their laws, sharing best practice and so on. So I think there are some opportunities, along with, of course, judges of the international tribunals dealing with migration and refugees, themselves through the association, sharing best practice and publishing the relevant documents. So thank you. Back to you, Jean-François.
Thank you very much. We are coming very close to the end of this session. I'll use my privilege as a moderator or chair to just pick one question which has just been put by Beatrice about the feasibility of a protocol on climate refugees. I think it's very difficult these days not to end a meeting on refugees without a discussion on the impact of climate change and disasters. And the way I would like to answer this is through a very short anecdote. I was lucky to be involved when I was still with UNHCR in some of the discussions in the early days of the UN Framework Convention on Climate Change, the UNFCCC, when UNHCR and others, IOM, the Federation, the Norwegian Refugee Council and others were trying to push for some language in the climate negotiations and more importantly in the climate treaties on displacement as a result of climate change and disasters. And I remember going to plead to inject some language, and I was going to meet the person who was the legal secretary of the UNFCCC. And I made a very quick summary of what refugee law was and where it was going and the possible contact points with the problematic of climate change. And that fellow looked me in the eyes and he said, yeah, I understand that, but what is it that you want in terms of hard law? And that resonated with me because, as I said, I have a soft spot for hard law. I'm very Cartesian. I'm a French lawyer. But that's an important point because the UN Framework Convention on Climate Change is this very interesting mix of hard and soft law. But clearly, binding commitments are at the core of it. And that is the clear message. I'm not suggesting that what we have on that score is ideal, but the intention to me is something that we should all take inspiration from. To have this mix of soft and hard law with a clear eye on making commitments more binding, more monitorable, more supervisable if that adjective existed. I will now turn back to you, Sarah. I believe that we have come to the close of the session. I would like to wish all the best in this conference and of course to thank our presenters and all the participants. And let's be ready for the coffee break. I really look forward to trying a virtual coffee break. I haven't had this for a while. Back to you, Sarah. Thank you all.